Hi, good evening actually. I left it a little bit later in the day to record than I was originally planning. Okay, let me just grab the book. Ugh. I gave my nice little booklet to Miss Olivia, so I'm in a big file today. Alright, so legal rights and obligations of parents and children. So, looking for the right page. Aha, okay, so we're starting on page 14. Okay, and the first thing we have is our red books, explain the legal rights and obligations of parents and children, including those derived from international law. So, in other words, we're looking at domestic and international law here. Part 5 of the Family Law Act ensures that the best interests of the child are met in any case involving children. This is the main consideration when making children's orders. Just looking for my cushion. Hang on a second. Ooh. I tidied my study today, so that's why the cushion's not on the floor next to my chair. Okay. Best interests, as listed in Section 60B of Family Law, include protection from harm, abuse, neglect, or violence, meaningful involvement in their lives by both parents, and adequate and proper parenting. This means that children have the right to know, spend time with, and communicate regularly with their parents and other people who are significant to their welfare/care. I think this last part comes about because of a foster grandmother, actually. Back in, I think it was the 80s, a local couple broke up. The wife had either sole or majority custody of the children, and the grandparents were not given the right to see their grandkids. Well, the mother didn't allow it. So they actually went to court and made it so that, well, they set a legal precedent that allowed grandparents the right to have access and visitation with their grandchildren. There you go, local knowledge. Okay, it also means that parents share the responsibility and obligations for their child's care and welfare. This wasn't always like this. Not sure if the case that I remember comes up here, but here we go. There was a lot of law reform that happened. The Family Law Act reform of 1995. Parental rights was changed to parental responsibilities. So there were terminology changes. The best interests of the child replaced the welfare of the child. Residence replaced the word custody. Can't remember if there's another one. Let's see. Oh, and contact was replaced by access. So once upon a time, there were certain parental rights and the welfare of the child was considered, and in that they looked at who had custody and who had access, and when people had access to their children. The new wording is a lot nicer and more child-centric because that is the aim. So now it is there are parental responsibilities to act in the best interest of their children. We look at the residence or main residence of the child, and we look at the ability for them to have contact with both parents and other family members. Okay, the second reform, the Family Law Amendment Shared Parental Responsibility Act of 2006. Parental responsibilities changed to something even nicer, to shared parental responsibilities, putting the onus on the fact that both parents should have a role in raising their children. The best interest of the child now includes the right to have a meaningful relationship with both parents. More terminology changes. Residence is now known as who the child lives with. Contact is now known as who the child spends time with and communicates with. So you can see those terminology changes more and more place the emphasis on what is in the best interest of the child. Areas of legal rights and obligations, that is, responsibilities of parents and children, are care and control of children. I'll go into all of these in a little bit more detail in a moment. Think what you like for the moment, what control of children is. Discipline, might have something to do with control. Education, medical treatment, and autonomy of children. Autonomy, if you remember, is a term we have come across before. If somebody has autonomy, it means that they have some rights to make some decisions for themselves. Okay, so parents have to have care and control. So care for children means that they provide adequate, that is reasonably good housing, medical care, financial and emotional security. This is from the Children and Young Persons Care and Protection Act of 1998, I can't read numbers. Control of their children. Parents are responsible for the development of appropriate social skills and monitoring their social behaviour. Child Protection and Parental Responsibility Act of 1997, New South Wales. So in other words, parents are supposed to raise their children to be able to operate within society as a valuable member of society. They should make sure they have the skills to go out into the world and watch to see how their children actually do behave out in the world, and if the child's behaviour is something which is not societally acceptable, try to remedy that. It is late. If parents are found to have failed in their duty of care, to care for and protect their children, and there is evidence of abuse, whether that be psychological and or physical, or neglect can be emotional or physical, then under the Children and Young Persons Care and Protection Act, the Children's Court has the power to remove the child from their family and relocate them within a more suitable environment. This is done through an application by the Department of Communities and Justice. This is the one I kept talking about before. I knew I changed it in the slides, just not in the first slide. I don't know how I missed it. Okay, so the Department of Communities and Justice was formerly known as the Department of Family and Community Services, FACS. Prior to that, it was DOCS. These are terms you probably are familiar with because whenever there has been cases of child neglect before, you've heard, oh, DOCS weren't doing their job, or you should report that to FACS. Now it's the DOCJ. I missed the C the other day. Discipline. The Crimes Act sets out some guidelines for judges when deciding whether an action could be legally defined as discipline or abuse. The following things are looked at and considered: the age, size, and health of the child, what the child has actually done, was it serious or not, the injuries that the child got from the punishment, the item used to hit the child, hands, fists, cane, weapon. These guidelines were added in by the Crimes Amendment Child Protection Physical Mistreatment Act of 2001, New South Wales. Okay, so obviously it's a bit of a touchy topic for parents these days when it comes to physical discipline of children. I know people who absolutely refuse to physically discipline their child, like they've never had a smack, and parents that have smacked their children. Personal experience might not be the same for everyone. My friend who firmly believes in not disciplining her child physically and has never smacked her before in her life has the most obnoxious, spoilt child I've ever met. My children, when they were little, they got a smack. If they tried to run out onto the road and there was a car or a truck coming by, they got a smack because they weren't of a rational enough mind to explain, hey, don't run into the road, the truck will squish you flat. My kids also would get a smack if they tried to put their hand in a hot oven because I figured, a quick snack was better than third-degree burns. But personal choice, I think you can see from the forms of discipline that I've said that I actually use with my kids that under these guidelines, it would not be considered abuse because, yeah, they got a smack. It was not like a punch in the face or a belt with a stick or anything like that. All right. Since the Education Amendment Act of 2009 in New South Wales, parents have to send their children to school between the ages of 6, or from the age of 6 until they complete year 10. Once they have finished year 10, they then must either be at school, TAFE, or in full-time employment until the age of 17. Well, yeah, not a bad rule. Like, I know a lot of the times now, kids are made to think that they have to stay at school till they're 17, but if they get gainful employment or go on to do training or education from another source, then that's fine also. And for some kids, school is not the be-all and end-all, and they will actually get a better start in life by going out into the workforce. But not you guys. Nah, you're too smart. Medical treatment. Parents are completely responsible for their child's medical needs until they are 14 years old. This includes appropriate medical supervision. That means taking care of them when they're sick and not just leaving them. Okay, this is a case that I think we bring up a couple of times in this section. So Thomas Sam and the Crown. The Crown versus Thomas Sam and Manju Sam, so husband and wife. Parents did not get adequate medical treatment for their daughter and she died. The father got 6 years imprisonment for manslaughter due to gross criminal negligence. So this case, what happened was their infant daughter had been seriously ill for days before Thomas and Manju took her to hospital. Chronic eczema. You don't think it's that bad, but chronic eczema, untreated, had left baby Gloria's skin raw and bleeding, but her parents were jet-lagged after a trip to India and too tired to seek medical help. It was only after the 9-month-old developed an eye infection that her parents changed their minds. Even then, Thomas Sam went to a morning church service before they took Gloria to a hospital, but as a court heard yesterday, this is from a newspaper report, they were already a week too late. By that stage, Gloria was too sick to be saved. Weak and malnourished, she died from infection in May 2002. Now, this wasn't Gloria's first brush with eczema. Gloria had actually developed eczema at 4 months, but her parents did not seek specialist medical treatment. The father, who practiced and taught homeopathy, preferred to treat her himself. Yes. The Sams were sentenced in the New South Wales Supreme Court yesterday after a jury found them guilty of manslaughter by criminal negligence, jailing Thomas Sam for at least 6 years and Manju Sam for a minimum of 4. Justice Peter Johnson said the baby's distress and the need for medical treatment would have been obvious. Okay, some more on medical. Oh, some more on here. Hang on. Oh, yeah. Sorry, this is more of the judge's judgment. The parents' failure to seek proper medical care, subjecting Gloria to significant pain over an extended period of time, could be characterised as cruelty, he said. So that's a form of abuse. Gloria was finally taken to the Sydney Children's Hospital in Randwick on May 5th, 3 days before her death. Staff had never seen a baby in such an extreme condition. Her skin, had been eroded by eczema. She was in severe pain and her hair had turned white. The court heard expert medical evidence that she'd been given medical attention. Had she been given medical attention a week earlier, she probably could have survived. The judge said that unlike others convicted of this crime, the Sams were intelligent and well educated with a supportive family network. It weighed against them in sentencing. Gloria suffered helplessly and unnecessarily from a condition that was treatable. Computer said no. Try again. Okay, there are three big issues here though when it comes to medical treatment and parental responsibilities. Number one, what if the parent don't want to seek medical help when the doctor says their child needs it? You'd think that would be easy peasy, but well, we'll learn about the Jehovah's now. Okay, so in 2009, the parents were Jehovah's Witnesses trying to stop their child from getting a blood transfusion to save his life. The court ruled that hospitals are allowed to give blood transfusions if there is no other option, even if the parents disagree. You may or may not know this, but blood transfusions is against the religious beliefs of people who are of the Jehovah's Witness faith. Another example where this happened is where the court ordered chemotherapy for a cancer-stricken boy, Oshin Kisko, after the parents refused. This headline tells you really all you need to know. The child had cancer. Parents said, nah, he doesn't need no cancer treatment. Judge said, yeah, he does. Number two, second issue. What if the parents and doctors want to force an operation, but their child doesn't need it? This might seem odd, but it's particularly true in what I'm about to talk about. So some parents try to force their intellectually disabled children to be sterilised so that they will be unable to have children. This could be either due to worries that the child will be similarly disabled or that they will have children very young, not knowing the responsibilities of parenthood at all, or not knowing that sex equals babies, and that they will not be able to take care of. A case here involved Marion in 1992. Treatments of sterilisation of intellectually disabled children are special medical procedures, so only the family court can decide in cases like this, even if the parents and the doctors agree it's best for the child. When it comes to issues around sex and intellectually disabled people, there have been numerous unfortunate cases of them intellectually disabled people being taken advantage of sexually by obviously a number of people because they don't necessarily understand what sex is. They don't have the capacity to make informed consent. I remember a couple of years back there was a pretty big case or big incident about the driver of a special needs bus who was forcing himself onto a young disabled female person who was being transported on a regular basis on that bus. It's sad. Okay. Okay. Well, there you go. I preempt myself every time. This happens so often that there was even a Senate inquiry into the involuntary sterilization of people with disabilities in 2013. The question was whether the current system, where the family court is able to authorise the sterilisation of girls with disabilities, is protecting the human rights of disabled girls. My body, my choice. It is a tough question. The third big issue is what if the parents, doctors, and the child want the operation, but it isn't medically necessary? Luckily, two decisions of the family court changed this. Marie Kelvin in 2017, stage 2 hormone treatment. Doesn't require court approval as long as there's no controversy. For example, if the doctor believes the young person can't make their own decision. And the next one, Matthew 2018, stage 3 surgical treatment. Doesn't require court approval, again, if uncontroversial. Now, I didn't specify there what that was about. So next case, make it a little clearer. In the case of Jamie in 2013, the child wanted gender reassignment treatment, and the court decided that, so yes, we're talking about a lot of gender-based stuff here. Court decided that if the child is under 16, the court has to decide if it's best for the child. If the kid is between 16 and 17, the court has to decide if the child is mentally able to make a decision. The judge decides if the child is Gillick competent. Either way, cases like this always had to go to court. This happened in Emory 2016, where they had to decide if the child was capable of deciding. This has been seen as legal interference in family decisions. A news article on this was push to end court control of treatment for transgender young people, the age 2016. This kind of plays a little bit into the next one, which is autonomy. Autonomy of children. If you don't know how to say it, it's autonomy. Autonomy. It means self-governance, being able to make your own decision. Children gain greater autonomy as they get older in a lot of different areas. It's unlikely that you will get an entire question just on this, so it's good just to know a couple of areas where children gain greater autonomy as they get older, and how the law has changed to reflect changing social values. Pardon me. It's just Coke, promise. Okay, so at 14 years of age, a child can seek medical advice. 16 plus is the age of sexual consent for both hetero and homosexual children. And 17 plus, they can decide if they want to leave school. So the courts and society recognise at these ages that children are able to make some decisions for themselves. So, for example, I'm not sure. Let's see if the button does what I want it to. It does. Phew. Okay, so this 14 plus. In the case of Gillick, this happened in the UK. Gillick's where we get the term whether or not someone's Gillick competent. They have the ability to make decisions. This was about a girl seeking contraceptive advice against her mother's wishes. The court overruled the mother as the advice was in the best interest of the girl to know about birth control. So any kid 14 years plus can go to the doctor by themselves. They do not have to have a parent present. The doctor is not allowed to discuss what occurs in a consultation between the child and the doctor unless the child gives consent for the doctor to have that conversation with the parent. With the age of sexual consent, it was, once upon a time, 18 for consent for homosexual sex, but there was an inquiry into the equal age of consent in 2003, and so the Crimes Amendment Sexual Offence Act was amended. The amendment was amended, and so it began that the age was 16. That created a uniform, same for everyone, age of consent to sexual intercourse of 16 years. Yay! Equality. Moving on. Okay, we are still under the same red box, but we are going to move to look at international law. So all those things we've just talked about come under domestic law. So our two main international treaties when it comes to looking at kids, or the legal rights and obligations of parents and children, the Convention on the Rights of the Child, 1989, or CROC for short, if you remember from Human Rights. I nearly said Human Resources, thinking Business Studies, and the Hague Convention of 1980. I've said it before and I'll say it again, you can just refer to it as CROC or the CRC. I think CROC's a little bit easy to remember. Every marker of the exam will know exactly what you're talking about. So this was a UN treaty, United Nations, on what rights children should have. This was a big shift from an old way of thinking to a radical new one. So once upon a time, children were seen as property. Parents had ownership and rights over their children. Violence against children is a family matter. What happens behind closed doors stays behind closed doors. This has shifted to, and the most important part, the best interests of the child are paramount. Parents not only have rights, but they also have serious obligations and responsibilities. Children are not property. Children are autonomous human beings with thoughts and feelings, and parents have to act in a way that is in the best interest of those kids. The CROC, Convention on the Rights of the Child, is the most widely agreed to UN statement. Every United Nations member, except for the United States and Somalia, are part of it. Even Palestine and the Holy See, or Vatican City, have agreed, and they're not even full members. Oh, sad. US and Somalia. Wait, no, Somalia ratified it in 2015, so now it's just the United States tops. You might remember we've discussed before, United States doesn't necessarily always want to sign on to agreements because they see themselves as the world leader and don't like the idea that they can be seen as doing the wrong thing. Like, they know what's best. Yep, they voted for Trump. Okay. Where am I? Conventions on the Rights of the Child, 1989. Here we are. The Family Law Legislation, Family Violence and Other Measures Act of 2011 brought the CROC into Australian law. So not only did we sign off on the agreement and we ratified it, we actually brought a lot of it back and incorporated it into our own Australian laws. And this was a great thing. It took 22 years. So as far as response, the response was a little bit slow on that one, if you're looking at evaluating. Okay. At the end of section 60B, it was added, an additional object of this part is to give effect to the Convention of the Rights of the Child done at New York on the 20th of November 1989. So it's specifically written into Australian law that we follow the Conventions on the Rights of the Child. The Hague Convention. Australia has agreed when children are wrongfully taken away from their home country to Australia that our government will return them. This was the issue in the Garning case, 2012. We looked at this back in prelim, the one with the 4 Italian girls. We sent the girls back because we would expect the same from other countries that have signed the convention. This is an international obligation that has been made into Australian law as well. It comes under Family Law Child Abduction Convention Regulations 1986. This works really well until an Australian child is taken overseas to a non-Hague Convention country. The failed 60 Minutes child snatch in 2016 was a result of this, because Lebanon was not a Hague Convention country. It did have an individual treaty with Australia, but it wasn't used in this case, with the mum deciding to go with the kidnap plan. Article 60 Minutes Treaty, 60 Minutes Treaty could help solve children's custody battle, the Australian 2016. And the clip of the 60 Minutes, actually I can't remember if the clip is from the actual 60 Minutes story or if it's an episode of Australian Story examining what happened. Either way, it's worth a watch. It's quite interesting and a little bit scary, but yeah, well worth looking at. Adoption. Hang on, I'm going to write down what slide that last clip was on so I can put it together with your supplementary clips. Okay, let's find a blank page. Oh my gosh, I've made lots of notes in this book. Okay, so that was slide. Alright, sorry about that. Adoption. Oh, that means we're getting close to the end, yeah. Alright, adoption occurs when a couple or individual person legally take another couple's child as their own. For this to happen, the biological parents have to legally renounce, give up their rights as the legal parents of the child and give consent, allow for the child to be adopted by another couple. The non-biological couple or person would then become the legal parents of the child. I'm pretty sure everyone's pretty comfortable with what adoption is, but just know that the biological parents do have to sign documents which gives away their legal rights as parents and give consent for the child to be adopted. Okay, so we've got here adoption rates. So, okay, so our small dotted line is children adopted from Australia. You can see between 92 and 96 it was relatively high, and then it started to decline. Just a tiny bit of an upswing from 2011 to 2017, but not much. Okay, our broken line is children adopted from overseas. Relatively steady through the early part of the 90s, throughout the 90s, early 2000s, a large bump. This was around about the time where it became somewhat trendy. Madonna adopted babies from overseas, Angelina Jolie, etc. And then the laws actually tightened up in overseas countries, so you see the decline there. And the unbroken line is total numbers of children adopted. It's gone from relatively high to much lower, and there's a few reasons for that. So let's have a look. From 2016 to 17, adoptions 315, 69 from overseas, 249 locally. There's been a 60% decline in the number of adoptions over the past 25 years. Adoption is a state matter, so every state has different laws around it. The state laws covering it in New South Wales is the Adoption Act, 2000, New South Wales. Nice, easy one to remember. The people allowed to adopt are married couples, including ATSI customary law marriages. They must have been together for 2 years, this is in the Adoption Amendment Act. De facto couples together more than 2 years, including same-sex couples, Adoption Amendment Act of 2010. Single applicants, whether they be straight or gay, the adoptive parents must be over 21 years of age. Males, there must be 18 years or more of an age difference between them and the child they adopt. And for females, 16 years or more age gap between them and the child. Why the disparity? You can make your own assumptions. I have never come across a clear, defined reason for that, other than people are more suspect of single dudes than single women, and I know that's a double standard, but it's the way of the world. Okay. 40 years ago, almost 100,000 adoptions occurred in Australia. In 2019-20, only 334 children were adopted in Australia. The number has dropped for a number of reasons, and they're good reasons. They show some progression in the world when we look at things like effective birth control and access to birth control. IVF, so in vitro fertilization, has allowed people who formerly were unable to naturally conceive to have children of their own. And there's now pretty much a 5-year average wait to adopt a child from overseas due to paperwork and procedures. About half of all adoptions were known adoptions. This is where a step-parent, carer or other family member adopted a child. Even when the adoption is an Australian child to an Australian family and they're already caring for the child, there are hundreds of adoptions just waiting for paperwork to be finalised for years due to government departments and court delays. It's come into the media a few times about speeding up adoption, and I'm going to look at one of them a little bit further down the line with people you might recognise. Okay, so the New South Wales government decided to increase adoption instead of keeping kids in long-term foster care when their parents weren't able to care for them. This was in response to having 18,000 kids in New South Wales in foster care, which doesn't give the kids a permanent home. There's currently, 2021 still? Yeah, it is. Oh my God, I have no idea. Currently, there are about 46,000 kids in New South Wales in foster care. So 2012, that article was talking about 18,000. 2021, that's 9 years later, more than double. Even at our own school, there are so many kids in out-of-home care. It's quite scary. It's not something that seemed to happen or wasn't really known about or talked about, I suppose, when I was growing up. And I see it a lot today, and it's something, because there's obviously a reason. Okay, so if children are removed from their families by the court and no other relative can care for them, adoption, open adoption, where there's still some contact with the biological parent or parents, is now the preferred option after the Child Protection Legislation Amendment Act of 2014 was passed. The controversial, I don't actually know, the controversial part of this is the risk of generating a new stolen generation. Though Aboriginal children are exempt from the law, yay, because stolen generation. Oh no, Samantha Armitage made some unfortunate comments on Sunrise a couple of years ago, which led to this coming back into the forefront of why the government has to be really careful about kids that are taken away from their families and putting them up for adoption. Okay, anyway, because what happens here? It was controversial. It places obligations on parents to get drug treatment or seek help. That's good. For example, if there's domestic violence and the mother refuses to seek help, her children can be taken away. But there might not be the resources available to provide that help. So some people who lose their children if they are drug dependent or in a domestic violence situation, for example, if you live in a small town in the middle of Watsonville nowhere, there's not necessarily a drug rehabilitation program running in your area. There's not necessarily a women's shelter that you can go to if you are a victim of domestic violence. That's why we have to be careful with some of these laws. Were the changes effective? Let's evaluate. In the year after the change, only 87 kids were adopted by their carers. The number of kids in out-of-home or foster care grew to around 20,000. The government decided that it was because the fax workers, they were fax at that time, now that they're DOCJ, the fax workers who deal with kids in foster care weren't encouraging adoption by their carers. It couldn't possibly be the fact that the government's funding in this area was completely inadequate. That's obviously irrelevant. So let's blame the poor, overworked government employees rather than, hey, government, fund these things if you want it to happen. That's just what's implied by the child protection workers urged to consider adoption in forums. Sydney Morning Herald article of 2016. Okay, adoption when it comes to same-sex couples. Same-sex couples being allowed to adopt is only a recent law reform, 2010, that is only 11 years ago. The members of Parliament were given a conscience vote, meaning that they were not instructed by their party leaders to vote one way or the other. So for cases that are basically around ethics and morality, sometimes politicians are given the chance to do a conscience vote. For most things that are voted on in Parliament, there's a party line. So the Labor Party might say, well, we want things to go this way, so everyone has to vote like that. The Liberal Party will say, we want it like this, so you all have to vote like that. In a conscience vote, you don't have to listen to what the party line is. It doesn't matter. You can't be victimised for it. You get to vote with your conscience. So what your feelings are about what is right and moral. So that's why it's a conscience vote. The law passed only after the faith-based adoption agencies, faith-based meaning God, for example, Catholic Care Adoption Services, were given the right to refuse same-sex couples to adopt because, well, everybody loves a little bit of bigotry here and there. Fred. Have you met Fred? Reverend Fred Nile, leader of the Christian Democrats. Fred Nile, it actually is Reverend Fred Nile, he tried to repeal the law to stop the gays from adopting. Adoption Amendment Same-Sex Couples Repeal Bill 2011, but it failed. Thank God. Jeebus works in mysterious ways. Inter-country adoptions. Okay, these are governed by the Hague Convention, which is a multilateral treaty, as well as bilateral treaties with individual countries, for example, Taiwan, Ethiopia, and South Korea, as seen in federal government to introduce changes to regulations for overseas adoptions. So, okay, multilateral treaty, the Hague Convention about how things should be, then there can be deals between two countries around how they treat adoption of children from one country to another. In New South Wales, parents must apply through the Department of Community Services for an inter-country adoption. Yeah, it's really DSCJ there. Probably should have changed that one too. Yep, I changed that, DSCJ. Okay, private adoption. Going overseas and getting a baby. I know people that have done it. And, hey, one of the happiest kids I know. This is only allowed if the adoptive parents have been living in the other country for at least 12 months and if the authorities in the other country approve of the child being brought to live in Australia. That is, you can't go on a holiday and come back with an adopted child. You used to be able to. But the laws have gotten stricter. That was one of the things I alluded to back when I was talking about rates of adoption falling. And after it was trendy, after Madonna and Angelina Jolie. Because everyone wanted to do it. Okay, a short supplementary clip here involving Deborah Lee Furness. Deborah Lee Furness is the wonderful blonde woman in that photo who is married to Mr. Hugh Jackman. Both their children are adopted, and she is an advocate for adoption in Australia, particularly looking at international adoption. So you can have a look at the supplementary clip that I will add to your resources. And watch some of her movies. She's amazing. Okay, my favourite one's Shame. There's still pretty serious ethical issues when it comes to inter-country adoptions. For example, the idea of what if they're stolen from their parents. It happened to a few couples from Canberra back in the 90s. Government repeals, ACT couples caught up in adoption scams. At one point, one of Madonna's children, David, he's got like a little hyphenated name, the father came forward and said that he'd never been given the opportunity to say no to the adoption, so he hadn't signed away his rights. As I said, got really trendy with celebrities adopting from overseas. Problems started coming up, and so the laws were tightened. And forced adoption. Oof. What was that really good show? Was it called Love Child? Love Child on Channel 9. You might have seen that a couple of years ago on TV. It kind of looked at this idea of forced adoption. So about 150,000 Australian babies born between the 50s and the 70s were forcibly taken with the support of the government from their mostly young and single mothers. The state and federal governments have now officially apologised. O'Farrell says, sorry, forced adoption. Barry O'Farrell was the New South Wales Premier at the time then. And Gillard delivers apology to victims of forced adoption. 2013, Julia Gillard, who was our Prime Minister at the time. Last one. Click. Click, god damn it, click. It's not clicking. You might have heard me just going click, 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 and I clicked all the way past it and I had to come back. Okay, I have also included in your supplementary materials an episode of Four Corners which looks at forced adoption in Australia. It's well worth having a look at. It's a horrible part of our history, but it's something we shouldn't shy away from the scary things in history. We should learn from them. Anyway, 45 minutes. I'm out. See you later, guys. Good night. Bye. Oh, I just wish I could elegantly press the buttons to lean forward. See ya.